expertise very few people have. He was an impeachment manager in the impeachment of Bill Clinton, and he also presented to the U.S. Senate at that time. And many of the U.S. senators wouldn't even go look at the evidence, but Bob did an incredible job. And we are honored that he's a Madison 4 member, and he's here to speak to us today on impeachment. Bob.
Thank you, Mike.
And Bob is a Madison 4 member.
Yes, sir. Listen, it's great to be back with you all, and I appreciate the opportunity to hear from Joe this morning. Great to see Bob Ott. We'll miss you on the commission. You've done a great job over the years. Really, we'll miss you there. Thanks. But it's great to be with you all. I always hate to correct a good friend, particularly after he's introduced me. But when Michael said that we had all of this evidence against Clinton, but few of the senators went to look at it, I have to correct you, none of them did. What I mean by that is very factual. When Ken Starr, the independent counsel at the time, sent the report to the Congress, and a lot of folks don't realize that the report that Ken Starr sent to the Congress in, I think it was October of 1998, he was legally required to do. It wasn't that he had it out for Clinton. It wasn't that he just decided that he would send a report to the Congress critical of Clinton. The federal law that set up or established the Office of Independent Counsel required that if in fact during the course of the independent counsel's investigation, and the parameters of that investigation were set by the court, not by Ken Starr, so he was simply following the court's mandate. But one of the requirements in that independent counsel law required that if in fact during the course of the investigation being carried out by the Office of Independent Counsel, they uncovered evidence of serious and impeachable offenses, the independent counsel was required to send that to the House. So Ken Starr was simply fulfilling his legal requirement when he sent that report to the House. And as you all may recall, that report came to the House, and it was several hundred pages long, lengthy report. But accompanying that report were file cabinets, boxes, full of supporting documentation, related offenses, and so forth, that the independent counsel had brought together that supported in great detail the offenses set out in the report itself. When all of that material came to the Congress, the House made two decisions. One, to release the report itself publicly, which was done. Secondly, though, all of that supplemental material, which really was voluminous, many file drawers, the House decided to keep confidential, away from the public. I don't think that was a wise decision, but that was the decision of the House. So all of that material then was sent to an office building right next to the Capitol, and it was available for any House member or any senator to review. Between the time that that material was sent to the House in October of 1998 and the commencement of the trial in the Senate in January of 1999, not a single senator took the time or had the interest in going and looking at any of that. Only a very few House members did also. I, of course, did, and the other managers did, but very few people did. But the fact that no senator took the time or apparently had the interest in reviewing any of the voluminous evidence that was available to the House in deciding and leading up to and then voting on the two articles of impeachment against Clinton, two violations of very serious criminal law. It wasn't jaywalking, it wasn't running a red light, it wasn't shoplifting. These were very serious offenses. Those offenses were, as you all recall, perjury, in other words, lying in an official proceeding under oath while president, and obstruction of justice. Not obstruction of Congress, which is not a crime. Obstruction of justice is a federal crime. And we laid out in the article of impeachment alleging that the president had engaged in a pattern of obstructing justice, very specific acts that he undertook. Trying to convince witnesses to lie under oath, providing gifts in an effort to prevent witnesses from testifying, and so forth. So all of that material was there, and it was part of the record, even though it was not public. It was part of the House record on the impeachment. The fact that not a single senator had an interest in or took the time to review any of that was an indication of a very clear illustration that the Senate was simply not interested in handling the impeachment. I don't know, do you have one of these, Michael?
No.
This is a book that I did a number of years ago after I left the Congress called The Meaning of Is. As you all may recall, that was the famous line of Clinton in his wordsmithing that he was very, very good at. Clinton was always very, very careful. He's a very smart man, very careful about what he said. Of course, we remembered, I think it was either yesterday or today, is the anniversary in early, January of 1998, where he went before the American people and wagged his finger and said, "I did not have sexual relations with that woman, Monica Lewinsky, not one time," and so forth. If you parse out what he said, technically, in his mind, he was telling the truth. He was like other folks that I dealt with when I was U.S. Attorney, who could say something in such a way, even though they were guilty of the offense, they could say it in such a way so that it wasn't technically, in their mind, an admission, so they could actually pass a lie detector test. And that's the way Clinton was. But the Senate was simply not interested in dealing with this. And I recount in the book, for example, between the time that we voted on the impeachment articles, December 19th of 1998, and when the trial commenced a couple of weeks later in the Senate, the Senate would send over one of their emissaries, a senator, and try and talk us, the impeachment managers, out of presenting extensive material. And they just didn't want to hear about it. They weren't interested in it. And the fact that not one of them looked at the material was illustrative of that. But it's interesting, there are, even though the two cases, 1998, 99, and 2019, 2020, are very, very different in so many ways, there are some similarities. So, for example, if you look at the Senate resolution that set out the rules that were debated at such length just a few days ago, that set out the specific rules for the impeachment trial, they refer back to two resolutions in the House that set out the House parameters for the impeachment. And that was very similar to what happened in 1998, 1999, because the Senate has to pass a resolution that lays out the specific rules for an impeachment trial. There are permanent Senate rules that lay out the general parameters of it. It says the Senate can call witnesses. Well, then the Senate has to decide for the particular trial whether or not they actually want to call witnesses. So even though you have these basic rules that are laid out in the permanent rules of the Senate, there always has to be a specific resolution that lay out the specific parameters for the particular trial. And in both the 1999 resolution and the 2019 resolution, 2020 resolution that the Senate just passed, both of them limit the material that is to be the body of evidence that the Senate is to use in rendering its decision to that evidence which was part of the House impeachment proceedings. That doesn't mean the Senate has to look at it. It just means that that's the body of evidence that is to be before the Senate in order for it to do its job. The Senate's responsibility is very, very specific, according both to the Constitution, which doesn't go into great detail. It just says the Senate has the sole responsibility to try, impeach, convict, or acquit. The House's responsibility is to decide whether or not a president has committed an impeachable offense. The Senate's job is to take what the House considered, that body of evidence that the House considered in investigating and reaching its decision, and decide whether or not, in the view of 2/3 of the senators, what the House did warrants the president's removal, conviction and removal. The Senate's job is not to do anything other than that. That's the job of the Senate. Take what the House sends it and decide in its mind, its collective mind, whether or not it warrants conviction and removal. And that's why in both the resolutions that set up the parameters for the Senate trial in 1999 and in 2020, it was limited to the record of the House. And in fact, when we presented the evidence against President Clinton in January and then February of 1999, that's what we were limited to, as it should be. So this notion that now it seems to be taking hold, and which forms one of the foundations for the Democrat argument to open this thing up, that we need new evidence and we need witnesses, is not consistent with precedent and the responsibility of the Senate. It's not the responsibility of the Senate to look at other evidence. If the House, in fact, would like the Senate to look at additional evidence or believes that it's necessary, then what the House needs to do is go back to the drawing board, present new evidence in the House, decide that there needs to be a different or an additional article of impeachment, pass it, and send that over to the Senate. It is not to open up what the House has already done to additional evidence and witnesses. Now, the question of witnesses is a little bit different. When we presented the trial in the Senate in 1999, the rule of procedures that the Senate passed provided for no witnesses. But they allowed that, well, maybe we will later on, which is exactly the same situation they're in now. But when Senator Schumer, who was there in 1999, and Senator Pat Leahy, who was there in 1999 from Vermont, when they tell the American people, and Schiff does this too, but he's a habitual liar, so it doesn't really matter.
No kidding.
When Schumer and Leahy tell the American people that there's never been a trial, an impeachment trial, never, without live witnesses, it's just a flat-out lie. Because in the Senate trial in 1999, even though late in the trial, the Senate did decide and vote to allow we, the impeachment managers, to take the depositions, that is, sworn statements under oath from 3 people, that was not before the Senate. Those took place in a hotel room off-site. 3 people where they allowed us to depose 3 people. But interestingly, this is just kind of a side note on that. Interestingly, the Senate said, well, you can depose these 3 people, but you can't ask them about anything that isn't already in the public record. And you're only going to have, I forget exactly how much time, but a couple of hours to do this. Well, as any trial attorney knows, or anybody who's been in or conducted a deposition, if you go into that deposition and the person you're deposing knows that you only have 2 hours maximum, say, well, it's very easy for them to delay. Oh man, need a coffee break, need a restroom break. Gee, let me think about that for a while. It's very easy to delay for 2 hours so that you get nothing out of them. And that, I mean, it was just pretty much a waste of time. But they were never live witnesses before the Senate. They were simply deposed briefly off-site so that the Senate could say, well, we did something. So there were no live witnesses in 1999. And the fact that the senators, Democrats, keep making this false statement that there were is simply that, a false statement. Now, of course, the primary difference, as we all know from watching the proceedings this last month really, but the last several days in the Senate, God, can you imagine sitting through that? It's just, you know, one of the rules of being a trial attorney is that you don't bore the jury. And I've seen it over and over again. The 2 cardinal rules of being a trial attorney, particularly if you're a prosecutor. One, you want to take the complex and make it simple. You know, I've seen a lot of prosecutors that take a very complex white-collar crime case and make it even more complex. You know, they over-try the case. They present too much evidence. They present too many witnesses. They present too many complex documents. The key is to take something complex and make it simple, understandable to the average juror, the average person. And the second rule is don't take too long. Well, I think the House managers have violated both rules, but you know, that's up to them. If you're given 24 hours to present a case over 3 days, which is ridiculous to begin with, in my view, don't take 24 hours. But they did. Just on and on and on. So what happened, for those of you that might have, and I didn't watch all of it, man, but you know, watch some of it and you know, then comment on it. Yeah, it was just repetition over and over and over and over again. And some of the statements were so outrageous that Jerry Nadler, you know, who was actually on the House Judiciary Committee back when I was in the House, when he made some of his outrageous statements, and then the Chief Justice, who serves per the Constitution as the presiding officer during an impeachment trial of a president or vice president, not in other impeachment trials, just in that situation. When the Chief Justice admonished both sides, that worries me a little bit, by the way. It was not anything, as far as I could tell, that the president's lawyers said that warranted admonition from the Chief Justice. It was what Nadler said on more than one occasion. And some of his language is just over the top. And to be over the top when they're already over the top is really something. I mean, but what worries me about what the Chief Justice did is that he felt the need to say, not just to the House managers, who were really the ones that were using language that was inappropriate, not just admonishing them, but he felt the need to admonish both sides. And it's this characteristic, and I think we saw this in the Obamacare decision several years ago, in which Chief Justice Roberts switched sides by all accounts that I've read, was part of the majority before the decision was made public. He was part of the majority to find that Obamacare was unconstitutional, period. Then he switched, apparently, very late. And apparently the reason that he switched very late was his main concern was the appearance of how this would look to the American people. We have to calm the waters. We have to be nice to both sides. That worries me a little bit.
Yeah.
Yes.
Because what we have coming up now, we have, of course, today, the president's lawyers, and I think the president has put together a very good team. Could have been better, if you'd asked me, but I'm not going to mention that. I'm not going there. I'm just kidding. But I think he has put together a very good team. I mean, Ken Starr, certainly if anybody in this country knows what an impeachment is and should be and has been, it's Ken Starr. And Pat Cipollone, who is the lead counsel for the president, I don't know him personally, but I know him by the tremendous reputation that he's had over the years as an outstanding attorney and a very highly ethical attorney. And Jay Sekulow, probably some of you all know Jay, who has been involved for many years with the American Center for Law and Justice up in Washington, which is conservative counterpart to the ACLU. Very, very smart man, very learned constitutional lawyer. So the president's team will start today. I think they're only going to take maybe 6 hours or something, relatively short time, today, and then continue with apparently the bulk of their argument, their defense arguments on Monday. I think is the current schedule. I obviously don't know what the president's team is going to, how they're going to present it, but I would certainly hope they would not take anywhere near 24 hours. In some respects, they could do it in just a few minutes, in my view, because the articles that the House of Representatives have sent to the Senate are so fundamentally defective that they should not even warrant the time of the Senate to do anything more than just, I would have thought, provide a motion to dismiss, directed verdict of acquittal or whatever you would normally see in a case that is so weak, so defective on its face in a regular court. This isn't a regular court, and I understand that. Or at least a vote to acquit without going through another 24 hours of arguments. And then, of course, they will make a decision after the senators ask questions, and Lord knows how long that's going to go on for. They have to, write them out, give them to the Chief Justice, and he'll read them. I don't know whether that means he's got to read every single one, or whether there will be some discretion. But this could go on for quite a while. On the one hand, dragging this thing out simply, in large measure, I think, reminds people repeatedly just how weak the case is. So maybe that's good from our standpoint. On the other hand, it does provide an opportunity for the House managers to do what they understand, but they're very crafty. Chuck Schumer should not be underestimated as a very, very crafty street fighter. I mean, he's very, very smart in that respect. I mean, I remember the first significant hearing in the House that I participated in early, it was the spring of 1995. Schumer was still on the House Judiciary Committee at the time, and we were having hearings on the tragedy in Waco. That went on for several days. But the very first day of that set of hearings in the House Judiciary Committee on Waco, actually it was a joint House Judiciary Committee and Government Reform and Oversight Committee, which did make a lot of sense, but I wasn't in charge. So we had this set of hearings, and the very first day, right out of the gate, Schumer ran rings around the Republicans in terms of his presentation and using the rules. And they did something that the Republicans at the time just didn't realize. The Republicans said, okay, we're going to take the morning for the presentation of our witnesses. And you, the Democrats, you can do this stuff after lunch. That was a serious mistake. what happens in the morning rarely makes it into the evening news. So right after lunch, when the Democrats were able to call their first witness, they immediately were able to switch the entire focus of that first day of hearings, which kind of set the stage for what came after. But Chuck Schumer is very, very, very crafty, very smart street fighter. And even though I tired, to put it mildly, of listening to Schiff and the other House managers, they do understand that if you say something sufficient times, regardless of the truth of it, people will start to believe it simply by fact of repetition. They've been very smart at that. You know, if you go back and you look at the words that they use, cheat, and even though a lot of that language is just outrageous, talking about Trump being evil. Some of the language, I think one of the House managers talked about, referred back to President Roosevelt after Pearl Harbor. This will be a day that will live in infamy. Right? Just outrageous statements. I mean, comparing what President Trump did, in my view, entirely consistent with not only the responsibility of a president, but what a president should do, and that is to ensure that U.S. taxpayer dollars, before they are actually sent to a foreign country, ensure that they are used consistent with our laws and consistent with what we believe is necessary, and that is without corruption. But to compare that to World War II, the evil of Nazism, Japanese Empire, attack on Pearl Harbor, it's just ridiculous. But of course, in large part, the audience that they're speaking to, the House managers, that is, a lot of people have no idea what Pearl Harbor was. They don't know that saying this will be a day that will live in infamy is simply a ridiculous recitation or comparison to something that happened so many years ago. To them, they say, oh, that sounds really bad. So repeating this stuff over and over and over again, even though to us, and I suspect to most of the senators, you just sort of tune it out because it's just repetition and it's ridiculous statements. President Trump, you may disagree with them, but call it evil, I mean, it's just ridiculous. They keep repeating these things over and over again, and it does take hold. A couple of other points, Michael, before we open up for questions. You see, of course, polls. I mean, they poll everything nowadays. Well, they poll the American people to see whether the American people would like think that there ought to be witnesses. Well, what is the familiarity that most Americans have with witnesses? It's watching TV. Whether it's my generation watching Perry Mason back in the 1960s, actually in the late 1950s, I guess, or nowadays with Law and Order, for example, one of the more popular, consistently popular TV shows. Everything in that courtroom turns around witnesses. And of course, there's almost always going to be that surprise, that key witness that changes dramatically the color of the case, the nature of the case. So, yeah, it doesn't surprise me that 80% or whatever of people polled, if they were asked, well, should there be witnesses? And oh, of course there should be. Because in their mind, most Americans have not been in court, do not participate in proceedings. They don't know what really goes on. Their impression is, well, of course there have to be witnesses. Every case that I'm familiar with, there are witnesses. So of course, that doesn't surprise one at all. But fundamentally, what is happening here is it's an attack on the foundation of our nation's, the fabric of the constitutional republic that our nation has been operating under very successfully, despite the ups and downs, for well over 200 years now. Impeachment there are many very unique provisions in our Constitution. The explicit recognition of the right to keep and bear arms is a fundamental human right being among them. And the right of the people to remove their elected leader through their representatives lawfully if that leader abuses their office in ways that are within the parameters of what the Constitution says. And the Constitution says only treason, bribery, or other, emphasize other crimes, high crimes and misdemeanors. So that entire phrase, which is the sole basis on which a president or vice president or other high officials of the government can be removed, very clearly on its face establishes that there has to be a crime, treason, bribery, or other high crimes and misdemeanors, and not just any crime, a serious crime. We believed as House managers in 1999, and the House of Representatives by majority vote, in which there were several Democrats that voted with us to impeach President Clinton on those two articles, we believed and set out a strong case that perjury and obstruction of justice are high crimes within the definition and meaning of that term. We had witnesses who would come in, people who, former government officials who had been prosecuted and convicted for those very offenses. So if this, already I think great damage has been done to that wonderful provision in our Constitution that gives we the people the power to remove a president for very serious offenses. Great damage has been done to it because of the nonsensical basis on which these articles were based, alleging no violation, much less a high crime, no violation at all of any crime. The use of office is not a crime. A president can abuse his or her office by committing serious offenses, but abuse of office in and of itself is not a crime, and obstruction of Congress is not a crime. It's just made up things. So, setting that precedent that the House has already done, and that the Senate has allowed to continue by refusing to dismiss these articles when they came over as being facially defective, fatally defective, has already been done. So our job as people who care about the Constitution, who understand the Constitution, our job is to do everything we can, certainly to make sure that the Senate does not do something completely crazy, and to do what Madison Forum and other groups, organizations in which we're involved do, and that is to educate the public, to try and undo the damage that has already been done to the constitutional framework of our country by these ridiculous articles that have been passed by the House and by the Senate, particularly the Senate Republicans, a few of them simply not having the courage to stand up to what the House has done and say, this is nonsense. And if you send us, if you, the House, send us articles of impeachment that are both substantively and procedurally so defective that they don't rise anywhere near to the level of an impeachable offense, we're not going to take people's time and to further allow that constitutional foundation to be further eroded. We're just going to dismiss it. The Senate hasn't done that. Hopefully, through the White House attorneys are going to present, will make that clear to the American people, and the Senate will then quickly dispose of it. But we have, particularly in this group and others, regardless of what happens in the Senate, we need to get out there constantly and try and educate the public to try and undo some of this damage that's already been done. So again, thank you for what the Madison Forum does. Thanks for having me today.
Bob, thank you very much.